All right, court will resume with the July 19th, 2022 docket. And let me see here, Miss Singletary, I believe you have F 0904-22-4 in the matter of the marriage of Efraín Zapata and Carolina Zapata.
Yes, good morning, Judge Lopez Singletary here on behalf of Mr. Efraín Zapata. He is a petitioner, Your Honor. However, I don't see him logged in. I see a different Hugo Zapata, Judge, but that's not my client.
That's not your client right there?
No.
Okay.
He was supposed to be logged in, and then Carolina is pro se, Your Honor.
Okay. We're looking for Efraín Zapata. Let's not divorce the wrong person because we'll get in trouble.
That didn't look like my client. I'm trying to message him to log in, Judge, because that was not.
Yeah. The wife may get upset if we divorce him.
Yeah, and
without the wife.
That's Miss Carolina Zapata. That's you, correct? Let me see. Yes, that's her. That's correct, Miss Zapata.
All right. But now we need Mr. Efraín.
Efraín, yes, Judge.
All right.
We have this person under iPhone, but
maybe
I don't know. There's no name. So
maybe the iPhone person, but he needs to come in so we can.
I'm messaging him.
Well, no, that's a young lady. So,
yes, I'm calling him.
Yeah, we don't have any Efraín Zapata in the waiting room unless he's under another name.
Unless he's
Mr.
in
Zapata,
another.
you logged in?
Hello?
What is your name, ma'am?
Leslie Avendaño.
Leslie. What's your last name?
Avendaño.
Avendaño.
Leslie Avendaño. Who's your lawyer?
Diana Fuentes.
Diana Fuentes. We don't have her for her.
Yeah, she's the lawyer.
Number 8.
She's number 8.
All right, number 8. Oh yeah, here we go, number 8. That'll be under iPhone.
Mm-hmm.
All right. Yeah, we still need Mr. Efraín.
Judge, he is having trouble. He is logging in, Your Honor, again. I think it kicked him out. He's putting in the.
Okay. And if we don't succeed, we might have to use a speakerphone. I think we can get him to there.
Yes, Mr. Zapata, let me know when you're in. He says that he should be logging in, Judge, again.
Okay. There it is.
There, okay, good.
That's gotta be him. All right. So, and let me see here. So, and Carolina is pro se, right?
Yes, Your Honor. And Ms. Zapata, you speak English, correct? If you want to unmute yourself.
No, she said Español.
You need to unmute Ms. Zapata.
Okay. She might need the services of an interpreter. I don't recall.
Up there.
Okay. So who's going to be testifying? Mr. Efraín Zapata?
Yes, Your Honor. I just need to make sure. Ms. Zapata, do you speak and understand the English language?
Mande.
¿Entiendes español en inglés?
Español.
Okay. You didn't bring your lawyer and you didn't bring an interpreter, right? No trajiste interpreter.
No.
¿Y qué vamos a hacer? How are we gonna explain it to you? What we're gonna do is we're gonna put on Mr. Zapata because he's the you need to interpret this. He's the petitioner, and then I guess we'll explain to you in a nutshell what happened here. So, is it agreed to, Ms. Singletary?
It should be agreed, yes, Your Honor.
Okay, let's put him on, and then in a nutshell, I guess we'll explain to her.
Lo que va a pasar ahorita es la abogada de tu esposo le va a preguntar preguntas, se va a poner todo eso en inglés y después te explicamos qué fue lo que el testimonio de, o tal vez la abogada te pregunte a ti preguntas.
Okay.
Yes,
all right. Court will take judicial notice of the entire file in F0904-22-4 in the matter of the marriage of Efraín Zapata and Carolina Zapata. Mr. Zapata, please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down, listen carefully to the questions, and Ms. Singletary, you may proceed, ma'am.
Mr. Zapata, go ahead and state your full name for the record, please.
Efraín Zapata.
Okay, and you lived in the state of Texas for the past 6 months and in the county of Hidalgo for the past 90 days. Is that correct, sir?
Yes.
And your marriage to Ms. Carolina Zapata, you and Ms. Carolina Zapata were married on or about June the 11th of 2010, and you separated of January the 1st of 2022. Is that correct?
Yes.
Okay, and your marriage to Ms. Zapata has become insupportable because of discord and conflict that ends the legitimate ends of the marriage. Is that correct?
Yes.
You and Ms. Zapata are not going to reconcile, correct?
Correct.
And during the marriage, you have 3 minor children: Sofia Zapata, born October the 17th of 2014, Ana Lucia Zapata, born February the 16th of 2017, and Efraín Zapata Jr., born on November the 8th of 2019. Is that correct?
Correct.
And no other children were adopted, correct?
Correct.
Now, you and Ms. Zapata have entered into an agreement where both of you are going to be named joint managing conservators of the minor children. Mom will be primary with the restriction to Hidalgo County. You will have standard visitation as per the family code, including all holidays. You will be paying Ms. Zapata child support in the amount of $1,500, and that'll be commencing August the 1st of 2022. Mother will keep the children enrolled through the government program, and you will reimburse the state in the amount of $57, also commencing August the 1st of 2022. You will also provide for dental insurance. There's going to be a retro child support judgment of 0 as of July the 19th, 2022. Is this your agreement, Mr. Zapata?
Yes.
Now, you and Ms. Zapata have also entered into an agreement regarding division of property. And this is the agreement. Your wife will keep any and all household furniture, personal belongings, equipment, all of her jewelry, any personal effects that she has in her possession. She's going to keep all the cash that she has in her possession, including those in the bank, including checking and savings accounts, any and all life insurance policies, insuring herself, any and all retirement or any other type of mutual funds or stocks on her name. She's going to also be in charge of any and all debt as of today, July 19, 2022, incurred solely under her name. Is that the agreement, Mr. Zapata? Your agreement?
Yes.
Now, as for you, you're going to be keeping the home located at 1909 South 46th Street in McAllen, including any and all debt. That home is still owed. Is that correct, Mr. Zapata?
Yes.
You're also going to be keeping the property located at 5188 Guerra Street in Rio Grande City, and your business with your part of the business with JL&E Trucking. Is that correct?
Yes.
Okay. You're also going to be keeping any and all your personal possessions, any jewelry, anything that you have. You're also going to be keeping any bank accounts, checking and savings, 100% of any pensions or retirements that you have with your present or current employer, including any and all also life insurance policies that you have insuring you under your name. You're going to be keeping any and all debt as well going forward as of today, July the 19th, that is incurred solely under your name. You're going to be keeping the vehicle, a Volkswagen 2019 Atlas, including any and all debt. That vehicle is still owed, correct, Mr. Zapata?
Yes.
And also the 2007 Prius. Now, there is a property, a home located at 183 San Juan Drive, Roma, Texas. That is your separate property. That is a home that belongs to your parents. So that will be included as a separate property and part of this decree. And this is the extent of your request. Is that correct, Mr. Zapata?
Yes.
Okay, is there anything else that I did not cover that I forgot, Mr. Zapata?
No, that's everything.
Okay. Now, Ms. Zapata, Judge, has she been sworn in?
Señora Zapata, levante su mano derecha.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the
¿Usted
truth?
jura que el testimonio que va a dar es la verdad, solamente la verdad y nada más que la verdad?
Sí.
Yes.
You may put your hand up.
Puede bajar su mano.
Zapata, I just read some terms and conditions into the record involving the minor children, child support, medical support, and also division of the property.
Señora Zapata, ahorita acabo de leer el acuerdo, los términos tocante a los niños menores, tocante a mantenimiento, aseguranza, médica, dental y visitaciones.
Sí.
Yes.
Sí.
And you're going to be receiving child support in the amount of $1,500 commencing August the 1st of 2022.
Usted va a estar recibiendo child support en la cantidad de 1,500 por mes con el primer pago empezando el día 1 de agosto del 2022.
Sí.
Yes.
And you and your husband, Mr. Zapata, entered into an agreement also involving the division of the marital estate. Is that correct?
Y usted y su esposo también entraron en un acuerdo tocante a la división de la propiedad del matrimonio. ¿Es correcto eso?
Sí.
Yes.
You're keeping all the furniture, any personal belongings, bank accounts, checking, safes, life insurance policies, and anything else that you have in your possession. Is that correct?
Usted se va a quedar con cosas personales que usted ya tenga en su posesión, incluyendo muebles, joyas, ropa, cuentas de cheque. Si usted tiene aseguranza de vida, todo que esté al nombre de usted, eso es de usted. ¿Es correcto?
Sí.
Yes.
And he's going to be keeping the house at 1909 South 46th Street in McAllen, and also at the 5188 Guerra Street in Rio Grande City, and pay off any and all debt associated with it.
Y el señor Zapata se va a quedar con la casa que está en 1901 Sur 46 en McAllen, y también la propiedad o la casa que está en 5188 Guerra Street en Rio Grande.
Sí.
Y también él va a ser responsable por cualquier deuda o taxas que se deban en esas propiedades. ¿Es correcto eso?
Sí.
Yes.
And he's keeping his part or his portion of JL&E Trucking. Is that correct?
Y también él se va a quedar con mitad del interés que él tiene en la compañía
JNL?
JNL?
JLE.
JLE Trucking.
Sí.
Yes.
Okay. And there's also a house at 183 San Juan Drive in Roma, Texas. That is separate property. It's a house that was purchased prior to your marriage and belongs to his parents. Is that correct?
También hay otra casa localizada en 183 San Juan Drive. I'm sorry, where was the city?
Roma.
En la ciudad de Roma, Texas. Esa propiedad es propiedad separada. Él compró esa casa o él ya la tenía antes de haberse casado con usted.
Él ya la tenía antes.
Yes, he already had it
I
before.
think it belongs to the parents.
Esta casa le pertenece a sus padres.
Sí.
Yes.
Okay, now Ms. Zapata, you don't have an attorney today, but you and Mr. Zapata have come into this agreement. Is that correct?
Señora Zapata, usted hoy no tiene un abogado que la está representando aquí hoy, pero anteriormente usted y el señor Zapata han llegado a un acuerdo. ¿Es correcto eso?
Sí.
Yes.
And you're asking this court to approve your agreement, Ms. Zapata?
Y usted le está pidiendo aquí al juez y a esta corte que aprueben el acuerdo que ustedes tienen aquí hoy, señora Zapata?
Sí.
Yes.
Okay, Judge, and we're asking for this court to approve this divorce based on insupportability, Your Honor.
Okay. And Ms. Zapata, do you have any questions?
Señora Zapata, ¿usted tiene preguntas?
Any questions?
No.
Anything,
Cualquier pregunta o algo que no entienda o
Okay.
inquietud o algo.
or any clarifications?
No,
Okay.
O algo que se le aclare.
No, todo bien.
No,
Okay.
everything is fine. Okay, gracias, señora Zapata.
All right. Court will take judicial notice of the entire file.
Last thing.
No. Do you want a name change or it's going to be?
Oh, I did not ask her. Ms. Zapata, you currently have Carolina Zapata. You want to change your name back to your maiden last name?
Señora Zapata, ahorita presente usted tiene el nombre de Carolina Zapata. La pregunta es, ¿usted quiere cambiarse el nombre de soltera o se quiere quedar con Zapata?
Con el nombre de soltera, no sé si se pueda.
Sí, sí se puede. Por eso es que es la pregunta, así para que se ponga en el decreto. ¿Y
Sí.
qué es el nombre de soltera? Yes, she wants her main name.
García.
García is her main name.
Okay.
So es Carolina García?
Sí.
Okay.
All right. Court will take judicial notice again of the entire filing cost number F0904-22-4 in the matter of the marriage of Efrain Zapata and Carolina Zapata. Hereby approve the agreement of the parties. Court will go ahead and dissolve the marriage of petitioner and respondent. Court will await a decree for signature. All right. Thank you all very much. You'll have a great day. Pasen buen día, okay?
Muchas gracias.
Thank
Bye-bye.
you, Judge. Can we please? Thank you, Judge.
Yes.
Have a good day.
Bye-bye.
Mr. Juan Viescas.
Mr. Juan, yes, yes.
And then I don't see Dora. Dora's missing? No.
All right, let's see here, Mr. Juan. Which is that one?
That's number 7.
Oh, number 7. Number 7. All right, Mr. Viescas. Good morning, sir. Good morning. You need to unmute Mr. Viescas.
Morning, Your Honor.
Good morning, Judge. Again, I have Manuel Zapata, the petitioner, with me.
Oh,
We're waiting for Dora Garza.
okay. I'm waiting for Dora Garza.
Judge. Your Honor, Hugo Zapata on behalf of co-counsel with Mr. Viescas on behalf of Mr. Zapata as well.
Okay, good morning.
And Angelina Zapata is on right here,
Angelina is on.
but we need Dora.
Judge, and for the record, Ms. Dora Garza has texted me and indicated to me she'll be logging in about 5 to 10 minutes.
All right, she must be busy in another court.
Yes,
Okay.
sir.
All right. You want to do somebody else or?
Okay, she just logged on.
She just got on. Okay.
Miss Angelina Zapata, you need to unmute and you need video, ma'am.
Okay, thank you.
All
Can
right,
you hear me?
okay. Yes, and that'll be Angelina Zapata, right?
Yes, ma'am.
All right.
Yes,
All
ma'am.
right. Good morning. And now we bring in now Ms. Garza.
Good morning, Your Honor. I do apologize. I was in another court.
Okay, no problem. You didn't take too long, not a problem. All right, I guess we're here on F4951-21-4 in the matter of the marriage of Manuel Zapata and Angelina Zapata. All right, court will take judicial notice of the entire file. And Mr. Viescas, you want to get it started, sir? Who's your first witness?
Judge, it'll be Mr. Hugo Zapata who will be conducting it. I'm just facilitating the
Okay.
petitioner.
All right, very well. Mr. Hugo Zapata, who will be your first witness, sir?
Yes, Your Honor, we'll call my client, the petitioner, Mr. Manuel Zapata Jr.
But, okay. Mr. Zapata, I see there's too many Zapatas. We're going to say the full names, okay? Mr. Manuel Zapata, please raise your hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may put your hand down, sir, and you may proceed, Mr. Hugo Zapata.
Yes, Your Honor, thank you. Before I get started, Your Honor, I'd like to just ask the court. I've never been before Your Honor before, so I don't know how the court wants us to prove it up. I'll give the court a little bit of background. This case was mediated. There is a mediated settlement agreement put in place for conservatorship, possession, there's an offset in child support, and marital property. So would the court like me to go through all of the terms?
Actually, yes, you can go, you briefly just tell them, was this part of the agreement that we did, regarding children or properties or visitation? And is that correct? You can even lead them on, okay?
Sure, Your Honor. One last thing, Your Honor. We do have 2 small issues, and I'm sure Ms. Garza will agree with me. We have 2 small issues in reference to the marital property. The crux of the division has been decided, just some small details that we were not able to agree on that unfortunately were either vague or not included in the mediated settlement agreement. We'd like to present those to Your Honor. They wouldn't require testimony, maybe just the position of the parties.
Okay,
Okay.
that'll work. We can take it up later. Okay.
Thank you, Your Honor. May I proceed?
You may proceed. Yes, sir.
Mr. Zapata, please state your full name.
Manuel Zapata Jr.
Okay, and before you filed for divorce, correct?
Yes, sir.
And before you filed, did you live in the state of Texas for at least 6 months?
Yes.
And you lived in Hidalgo County for at least 90 days?
Yes.
Now, you were married on May 28th, 2000, is that correct?
Yes.
And you separated as husband and wife on August 1st of 2021?
Yes.
Now, Mr. Zapata, is it true that the marriage to your wife has become insupportable because of discord and a conflict of personalities between you and your wife?
Yes.
And this destroys the legitimate ends of the marriage to your wife, and there is no reasonable expectation of reconciliation. Is that correct?
Correct.
Now, you and your wife are parents to 3 boys. Is that correct?
Yes.
Now, one of the boys just recently turned 18 and graduated from high school, correct?
Correct.
And obviously you're aware that therefore he is no longer part of this proceedings.
Yes.
So that leaves 2 minor boys, correct?
Correct.
All right. And the first one is Andres Josue Zapata, and the second one is Diego Ricardo Zapata. Is that correct?
Yes.
Now, you undertook a mediation between you and your wife, correct?
Yes.
And in that mediation, the parties basically settled all the more pertinent terms or subject areas in a divorce. Is that correct?
That's correct.
Now, in reference to conservatorship, you agreed through at the mediation to do a joint managing conservatorship, correct?
Yes.
In reference to visitations, you've also agreed to basically do 1 week with you and 1 week with your wife, correct?
That's correct.
All right. Summer visitations were also slightly modified. Instead of a week, there will be around 10 days in length. That's for the months of June and July, correct?
Correct.
And holidays will be controlled by or as per the standard possession order of the family code, correct?
Correct.
All right. Now, since both of you will have equal possession of the children, there wasn't really child support. Well, strike that. You all agreed to an offset due to the earnings of the parties, correct?
Correct.
You will be paying $1,000 starting June 1st, 2022. And that will be up to the time that the oldest child either turns 18 or graduates from high school or is emancipated for some other reason.
Yes. The youngest child. Yes.
Well, in this case, Andres, right? He's the oldest from the 2 that are before the court today.
Yes.
Okay. Now, once Andres either turns 18 or graduates from high school, whichever happens last, or he's emancipated for some other reason, there will be a step down, correct?
Correct.
And then that will be down to $800, correct?
Yes.
And that will be until the youngest child, Diego, either he turns 18, he graduates from high school, whichever happens last, or he's emancipated for some other reason.
Yes.
Now, you will continue, you are currently providing health insurance for the minor children?
Yes.
You're also providing dental and vision?
Yes.
And you will continue to provide that health insurance, dental and vision until your obligation ends as per the children either turning 18 or graduating from high school, correct?
Yes.
All right. There is no retroactive child support before June 1st, correct?
Correct.
All right. Now, in reference to the marital property, well, before I get there, the tax exemption for the children, it's the agreement in the mediation that you will claim the youngest child for 2022 and in future years,
Yes.
and your wife will get to claim Andres or the 2 oldest children for 2022 and in future years, correct?
Correct.
All right. In reference to marital property, you're asking the court to award you all household furniture, clothing, jewelry, and other personal effects that are currently in your possession?
Yes.
And whatever furniture, clothing, jewelry, or personal effects that your wife might have, she gets to keep those, correct?
Correct.
In reference, you're also asking the court to order that you keep all your cash in possession, including money in bank accounts, which stand in your name only?
Yes.
And any monies that your wife might have in her possession, whether cash or in bank accounts at this time, she gets to keep, correct?
Correct.
You have a retirement plan with the federal government, your federal employment retirement system account, correct?
Correct.
The agreement at the mediation is that you will keep 100% of that account as your sole and separate property.
Yes.
Okay. Now you also have a, what we call a thrift savings plan, which is essentially like a 401k through the federal government as well. Is that correct?
Yes.
And the agreement at mediation is that your wife is awarded 60% of that account and you are awarded the remaining balance of the 40%, correct?
Correct.
Now the judge, there is an issue, a small issue on that subject that we can get back to
Okay.
If the court will allow. Thank you, Judge.
All right.
Your wife, she has a teacher retirement system account, is that correct?
Yes.
And she's being awarded 100% of that as her sole and separate property.
Yes.
Motor vehicles, you are keeping, as per the agreement, a 2006 GMC Sierra pickup.
Yes.
And there's also a Honda Civic. What is the year on that vehicle, sir?
I believe it's a 2017.
You'll also be keeping the 2017 Honda Civic, correct?
Correct.
All right. And you'll be keeping the debt that's tied to that Honda Civic and any debt that might be tied to that pickup as well, correct?
Correct.
Your wife will be keeping a 2004 Toyota 4Runner?
Correct.
Any vehicle that she might have obtained since the mediation, she'll be keeping as well, correct?
Correct.
And any debt tied to those vehicles.
Right.
In reference to the marital home, you all bought a home which is located at 9621 North Benson Road in McAllen, Texas. Is that correct?
Yes.
Now that property, along with all improvements or anything tied to that property, that's being awarded to you as your sole and separate property, correct?
Correct.
All right. Now, your wife, through the settlement agreement, through the mediated settlement agreement, she's agreed to receive a payment in the amount of total $80,000 for her interest in that home.
Yes.
40%, I'm sorry, 40,000. There will be an initial payment of 40,000, correct?
Correct.
And that payment will be made here shortly, correct?
Yes.
Now, there is a payment, the balance, which after the first payment should be $40,000 left. That payment is due on or before November 9th, 2024. Is that correct?
Yes.
Okay. And Judge, this would be, there's a small detail on this second issue that we can present to the court. Thank you, Judge.
Okay.
As far as debts, you'll be keeping any credit card debt that might be in your name?
Yes.
Any debts associated to the vehicles you're being awarded, you will keep that as well?
Yes.
Any debt associated to the home that's been awarded to you and that you've agreed to keep, that will be your debt as well?
Yes.
On the thrift savings plan, on the TSP, there is a loan pending. You will be responsible for that as well.
Yes.
And I believe you had a personal loan, small amount, that might already be paid off, but if it's not, you will be responsible for that, correct?
Correct.
And it's been agreed that your wife will keep any credit cards in her name, any debt associated to any vehicles she might have. Is that correct?
Yes.
And she will keep the student loan debt as well, her student loan debt under her name.
Yes.
Just in reference to any IRS, past IRS liabilities, are you asking the court to order that if there were to come any federal income tax liabilities from past years, as you all have been married for almost 21 years, you're asking the court to order that those will be split equally between the parties in the event something were to come up. Is that correct?
Correct.
And that would be just through 2021, which was the date of separation.
Yes.
So in the event that the IRS would come back and say, hey, you underpaid in, say, 2015, you owe us money, then you're asking the court to order that be the responsibility of the parties in equal amounts.
Correct.
Okay. Are you asking the court to approve this agreement and grant the divorce today?
Yes.
Your Honor, that's all the questions I have of this witness.
All right. Thank you, sir. Ms. Garza? You need to unmute, Ms. Garza.
If I can just clarify with opposing counsel on that last, the income tax issue. Was
Right.
that in the mediated settlement agreement, Mr. Zapata?
No, I don't believe so. I don't
So
believe
that
it
was
is.
just added by you right now?
Well, it's just something that I usually, it's a usual term. If you don't want to agree to it, that's no problem. We don't have to add it. I believe it's in the decree, but.
All I would say, Judge, is if they did file their income tax together for 2021, or the years prior to that, then I would agree that, they filed together. They would be liable to IRS for anything that comes up later. But if they did not file together for 2021, why would Ms. Zapata have to be liable for anything?
And I would agree with that, Your Honor. I assumed that it was filed
Okay.
together, but it might have not been. But I guess we could
Right.
leave it to up to the year where they filed together.
Yeah,
All right.
Yeah,
that'll work.
together. I
Okay.
filed together.
Okay. Okay, Ms. Garza, will you call Ms. Zapata as your
Yes,
witness?
Your Honor.
All right, Ms. Zapata, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may put your hand down. Ms. Garza, you may proceed.
Yes, Judge. Ms. Zapata, you heard the testimony of your husband as to the agreement that both of you reached during mediation, correct?
Yes.
Is that your full understanding of the agreement?
Yes.
Except to the two issues that we will take up with Judge, correct?
Yes.
Is there anything else that you feel we are missing or should be added to that testimony?
No, not at the time. No.
There is one that I just remembered and I want to clarify for the record. As far as the health insurance, Mr. Zapata does carry the insurance through his employer. But there's also for anything not covered by insurance, the agreement is that each party will pay 50-50 for anything outside of the insurance.
Yes.
Is that correct, Ms. Zapata?
Yes.
Okay. I have nothing further for Ms. Zapata, Your Honor.
Okay. Then the other two issues, what was it again? One dealing with the 401k?
Yes, Your Honor. The first one, well, yes, we can address that one. It's with the TSP, with the Thrift Savings Plan.
Uh-huh.
The agreement in the mediated settlement is that the respondent be awarded 60%, Mr. Zapata be awarded 60% of that account, and that Mr. Zapata be awarded the balance, which is 40%. The disagreement that we have is the cutoff date. Our position is that the value of Ms. Zapata's 60% would be as of May 5th, 2022, which was the date of the mediation. If the court would allow me, I can share my screen and point out on the mediated settlement agreement, if the court would like. If not, our position is that it would be as of up to May 5th. Obviously, my client continues to be employed. He continues to contribute to his TSP through his paychecks. The parties have been separated for a significant amount of time. And again, the mediated settlement agreement does have some language that says the effective date, I'll read it. This mediation agreement court order is applicable and enforceable immediately upon signing by the parties and their respective attorneys. We interpret that to be that on that date, May 5th, yes. And then further, Your Honor, further in the mediation agreement, it does say that the respondent, her 60% is based on current value. Again, we interpret that to be on that date. So we would ask that language be in the decree, that her 60% is to be calculated as of that date. As of that date, and anything further would be my client's.
All right, Ms. Garza?
Our response, Judge, is that the mediated settlement agreement is very clear on every issue. This being one that wasn't clear as far as the cutoff date. It was not talked about during mediation. For that reason, we are asking that it be customary to the signing of the decree of divorce. That is the date we should use. That is our argument, Judge.
Okay, and what was that language you read a while ago, Mr. Zapata?
Yes, Your Honor. Again, if the court would like, I could put it up on the screen.
Can we share the screen? Yeah, let me see if I can share the screen right now. I want to do it right now.
I can share it from my end, Your Honor, I believe.
Yes, it's ready.
Okay. One moment, Your Honor. I will pull up. Your Honor, this is, if you could tell the court, it's a filed marked. However, this is a copy that I've marked for my notes.
Okay,
If the court can look at page 206 where it says effective date,
okay,
the second sentence, this mediation agreement / court order is applicable and enforceable immediately upon signing by the parties and their respective attorneys.
immediately. Okay,
Yes, and then even further, Your Honor, on page, I believe this is 6 of 6, and again, it's got my highlights for my notes. Right under property to husband, it talks about the TSP account. It says her 60% is based on current
value.
Again, we interpret that to be on that date.
Okay. All right, then we'll use the May 5th date.
Thank you, Your Honor. Your Honor, in reference, the next issue is in reference to the $80,000 to be paid to the respondent for her interest in the home. I think Ms. Garza would agree here. The language in the mediated settlement agreement is vague, but it's in reference to if Mr. Zapata does not pay on or before November 9th, 2024. Now, the language in the mediated settlement agreement reads as follows: if fails to pay on or before the date of the balance of $40,000 to earn interest of 10% commencing November 9th, 2024. If the court would allow me, again, I could share my screen so the court can have a better idea.
All right, go ahead.
Yes, Your Honor. And this is right above here in highlighted in green. It says,
all right,
the sum to be paid, the balance to be paid on or before November 9th, 2024. The sum to be paid out of available funds. If fails to pay on or before the date, the balance of $40,000 to earn interest of 10% commencing November 9th, 2024. And then the house to be sold for failure to pay. The only issue we have, Your Honor, and I think Ms. Garza will agree, is the interest part. If Your Honor can see, it doesn't specifically say, is it, yearly, monthly, what did it say? So I had discussions with Ms. Garza. My understanding was that after my discussions with her is that she wanted to earn interest, and my understanding was that she wanted to put in there yearly of 10% commencing November 9th, 2024. She later told me that wasn't what she was trying to communicate to me. Our position is that be yearly, Your Honor. I think that's customary. If we put monthly, that would just be unconscionable. It's almost usury. It would be an extensive amount of interest if it were to put monthly. My understanding is Ms. Garza and her client's position is that they wanted to read monthly. So you're talking.
It should be annually, right?
And that is our position, Your Honor. Annually, we believe that that's customary, that would be fair, that would be reasonable, that would not be unconscionable. It would be start earning interest at 10% yearly. On the balance going forward, November 9th, 2024, that payment's not made. So that's what we would be requesting from the court.
Okay. Ms. Garza, you want to say something?
Yes, Your Honor. Our position on that is that he's getting, what is it, about 2 years or a little bit over 2 years, Judge, to pay this amount. And that is why we added that 10% in there as an incentive for him not to go beyond that November 9th, 2024. So whether it's unconscionable or not, I believe, he has, he's keeping the home. He is to pay her the interest. She gave him some time. She wants him to be punctual and pay on or before November 9th, 2024. The other thing too, Judge, is maybe if we can add on there that if he does sell the home before that date, that he is to pay this amount immediately, if they want to keep this interest, at a low yearly. Because what if he does sell the home within a year and Ms. Zapata has to wait for him to, at a 10% interest, to pay whenever he wants?
And it wouldn't be paid whenever he wants, Your Honor. The date is clear on the MSA. Again, the interest, it is addressed that it would be 10% interest. Yeah. The only vague part was it monthly or yearly? And it's our position.
why would we agree at a year? What would be the incentive to Mr. Zapata to pay her on time by November 9th, 2024? Like, she's giving him more than 2 years to pay. And then for him to come around on that day and say, well, I'd rather pay the 10% every year, you know, and prolong this. That is a reason we have the 10% in there, so that he knows that he has to pay. So if it's per month, I'm sure he's not going to want to pay that monthly interest, because, you know, it's going to add up pretty quickly.
Okay.
May I
Yes,
go,
sir.
Ms. Garza? Thank you, Judge. Your Honor, I mean, Ms. Garza is making assumptions that my client is gonna, you know, not want to pay. I think the respondent is fully aware that my client is a man of his word and that he will pay when he's supposed to. Now, again, the language is in the MSA. The only thing that's left out is whether it was yearly.
Yeah.
That we believe that I mean that would be the reasonable thing, Your Honor, to do monthly.
Yeah.
No party would agree to that.
And Judge, if Your Honor is inclined to following the yearly, I would say then we can add, if the home is sold before that, then, you know, he is to pay her interest, remaining interest, within 10 days of closing, so that at least she's not lingering there and the home has already been sold.
And Your Honor, the 2-year gap was taken into consideration at the time of
Right.
the mediated settlement agreement, because it is a large amount. It's $80,000. My client
Right.
is keeping the balance on the home as well. He's paying an offset in child support. It's a lot of expenses for him. So that he was given those 2 years as part of the agreement to give him time to breathe and be able to make those payments.
Right. But if he sells a house before that time, wouldn't it be better for him just to pay everything right off the bat and get
I
out of the
believe
debt?
so, Your Honor. I don't believe my client would have any issue with that.
I think that's a fair deal.
Yeah, I wouldn't have a problem. I sell the house, which I don't have any plans to sell the house. That is the house my children grew up in. I'm a man of my word. I mean, I'm a law enforcement federal agent.
Okay.
I don't make a habit of lying or cheating my children out of anything.
Right.
That's
Right.
what it's all about. But 10 days is too soon after closing. That's unreasonable as well.
No, you just make it, 30 days after closing. Yeah.
Yeah, I mean, I don't have a
Yeah.
problem with her what's fair. But,
Okay. Okay, we'll make it the 10% annual or yearly, and then upon selling the house, if you do sell it, then to be, you know, the balance to be paid within 30 days of closing.
yes, sir.
Okay.
Sure. Thank you, Judge.
Your
All
Honor,
right.
I believe that's all we have, Your Honor.
Anything else, Ms. Garza?
No, Judge, that's it.
Well, the court will take judicial notice of the entire file in F4951-21-4 in the matter of the marriage of Manuel Zapata and Angelina Zapata. Court will hereby approve the agreement of the parties, will dissolve the marriage of petition respondent, and will await a decree for signature. All right. Thank you all so much, and good luck. You all have a great day. Okay.
Thank you, Judge.
Your Honor, thank you so much.
Thank
It was
you.
a pleasure presenting this
Yes,
case
pleasure
before you.
meeting you,
Nice to
sir.
meet you.
Yes, sir.
Yes, sir. Thank you.
Judge. Bye-bye.
Number one,
Number one.
Mr. Solis and Mr.
All right. Mr. Solis.
So that's
Yes, sir. And Mr.
is
Zagoras. No.
asking the plaintiffs to produce documents that they're required to produce.
Your Honor,
94.2
right now
F3.
I'm about to argue
basis
a
of the
case in
motion
Judge
to
Palacios'
strike
court. Can my case be recalled in 5
that-
minutes?
Yes, sir. Yes, sir. Okay.
I'm showing you the screen that I'm on my computer. This is on my phone.
And
All right. All right.
they have not.
Okay, we
You
have
want this?
number,
Yeah.
Ms. Lauren Smith and Yuri Young's number 3, number 4, and number 5.
3, 4, and 5. That's the same one.
Yes, sir.
Let's do it. We'll be right back to Mr. Jerry. All right. Let's see here. We have Mr. Yuri Youngs and
Mr. Young.
Miss Lauren Smith.
Yes, Your Honor.
All right. Good morning. Thank you all for waiting. And Mr. Youngs, thank you for waiting. And what about the parties? Is that Roberto right there? And Juanita. Okay, I think they're there on the screen. Okay, folks, what do we have on this one? And this one is cause number F0445-22-4 in the matter of the marriage of Roberto Hurtado and Juanita Mendez.
Morning, Judge. Christopher Youngs. I'm standing for Yuri Rocio Youngs. We're actually number 3 and 5 on your docket. Ms. Rocio Youngs has filed for a motion for withdrawal at the instruction of her client, Ms. Juanita Mendez. I will say that Ms. Smith's office did reach out to us yesterday with the proposed Rule 11 agreement to reset the hearing on their motion for enforcement, which is number 3 on the docket. However, Ms. Mendez didn't give us permission to sign a Rule 11 to reset that hearing, but I'm standing here hoping to get the relief Ms. Rocio Youngs is requesting in terms of the withdrawal and have the court grant that withdrawal.
All right, motion to withdraw. And that'll be granted. So then we will not take any action on any of the motions, right?
Your Honor, I actually filed this motion in May, and I've been waiting on some kind of a response from the other side. I'm actually had to move around things to do this hearing now today. I would prefer to go ahead, and my client's been waiting for relief for over a year. We had in Rule 11 agreement. We had this case was transferred from Bexar County to here. My client is not getting to see his child. We have a motion to enforce. Like I said, it's been over 2 months. They've had plenty of time to withdraw. I don't have a problem with them withdrawing. I'm not asking anybody to, obviously go forward, but we do want to have it heard. I've been waiting now for a little while to get, some relief from my client too. And we have a final order. It's been entered. We had a Rule 11 agreement that has been entered. Any further delay is just going to benefit her from her bad behavior.
What is the Rule 11?
I have the Rule 11 on file here, Your Honor. It's actually part of my summary judgment, which I also had to file just because she's breached this contract. The Rule 11 agreement was signed back in December of 2021 when my client and everyone, this took place out in Bexar County. And Mom was allowed to, obviously, there was no geographic restriction, but at the time she wasn't allowing Dad to have real basic visitations such as Thanksgiving, just she didn't want to do the pickups and drop-offs, but that's for the motion to enforce. So we did come to an arrangement that should have solved the whole case. Coming up on now a year. So the Rule 11 agreement was signed by both parties, giving joint managing conservatorship. Mom is going to remain being primary. Dad would get first, third, and fifth Fridays, 6 p.m. to Sunday, 6 p.m. Pickup and drop-off is going to be at the Palmview Police Department in Palmview, Texas, which is their agreed upon designated location. My client would pay Mom $380 a month in guideline child support beginning in December. And then my client was supposed to get some access to some makeup time, which was agreed upon to be January 2nd to the 9th. And then alternatively, just 5 days of makeup time, Your Honor. And then after that, parties are going to split all the insurance, unreimbursed, reimbursed medical, just your typical 50-50, and then notify each other of any extracurriculars so they can both attend. And holidays and summers as per standard possession order. This was all signed by everyone and turned in. Ever since then, a client, I guess Juanita Mr. Hurtado has reneged, hasn't been allowing. So now we've had to do a summary judgment, a motion to enforce. But honestly, we just really want to enter this final order, which my client has been waiting on for so long, which reflects the agreement of the Rule 11.
Okay, so this is a divorce.
I'm sorry, Judge, if I may, I just want to add a little bit of additional context as to pretty much the procedural background since we've been involved in this case. The Rule 11 that Ms. Smith is referring to was an agreement entered into when Ms. Mendez was unrepresented. And when she had first retained us, our original, strategy in order to pursue in this is we were going to file a motion to set aside the Rule 11 agreement. And we had prepared that, but then Ms. Smith's office, upon our notice of appearance being filed with the court, asked us to mediate this case. We originally had a mediation date with Ms. Lucia Regalado serving as the mediator, but she was in a jury trial in the 93rd District Court at the time that mediation was scheduled. Then thereafter, we had scheduled mediation. I believe it was for June 27th or June 29th, just prior to mediation coming up. Ms. Juanita Mendez had told us that she no longer wants our services. So we had ceased work on the case because we wanted to be able to get the order granting our withdrawal before we could go ahead and close out the case. And we didn't want to add any additional billing or responses on Ms. Mendez's retainer with us. So that's the reason why I understand Ms. Smith wants to go ahead and proceed, and I know Ms. Mendez doesn't want my firm advocating for her right now, but I would say my recommendation would be, upon us being granted our withdrawal, maybe you guys can get a new reset date to go ahead on that. Just because if I'm not formally withdrawn from this, I'm not prepared to go on the enforcement right.
Okay, now, so what happened with the mediation? How come it didn't go through?
She no-showed, Your Honor, and I kindly took the whole day off to go to mediation. So did my client, and she had absolutely no respect or courtesy to let us know. She just no-showed. So I'm not
Okay,
setting
so-
up another mediation again.
So the kids right now are with Miss Juanita?
Oh.
Yes.
No.
How many kids?
No.
What are the kids?
The kid has been with Mr. Hurtado since June 15 for the summer visitation. He's been with him ever since. I've only seen him 2 weekends.
Okay.
I thought you were asking, Your Honor, who they live with. Mom is primary. Dad is
Okay, they live with
exercising
mom. Okay, but right now
Yes,
they're
that's-
sitting with Mr. Hurtado.
There's only one.
Only one child. Okay. So why is this thing taking so long? You all had something agreed in December, and now we're here in July, and
There's been some changes. I had asked Ms. Smith to, instead of Mr. Hurtado coming all the way from San Antonio to Palmview, that perhaps we could meet halfway in Alice or whatnot, so that the child support could stay the same. There's been some changes to the insurance. I've let Mr. Hurtado know, the child no longer qualifies for Medicaid, so I can't provide insurance anymore. I've asked him, I've heard no response on that. And there was some issues I wanted her to add as well for the address. They're actually the petitioners. I'm the respondent on the case.
Your Honor, she's, like she said, she's completely reneging on the offer. I mean, the child support and the pickup and drop off, this was all negotiated back in December. I thought
When
it
I
was
was
done and
pro
dusted.
se, when I was pro se, before I had been advised by an attorney.
So, like I said, this
okay.
Ms. Smith, you're on mute.
You're muted, Miss Smith.
I don't know what happened, where my video went. Hold on a second.
So Mr. Hurtado lives in Houston, San Antonio right now? Okay,
Yes,
she's
he
still
does.
muted.
There we go. Okay, sorry about that. Yes, Your Honor. So she wasn't represented, but she's over 18 and she agreed to this. This is something we all worked
No,
out.
but-
It's the first time I'm hearing about the insurance,
Okay,
but the pickup and drop off and the child support were really the only things we're fighting about. We thought it was all done and dusted. She wants, everything now to go her way and strip my client of all the benefits of the agreement, but keep all the things that he offered her. That makes no sense. That's not how
Well, no,
contracts work.
I think the main thing she asked was, number one, that that the drop off and pick off be done halfway. And number two, that she needs insurance now for the kids. Well,
That's the first I've heard of this, Your Honor.
That's supposed to be
that's the
paid
first I've heard of it.
by the father anyway, right? But
Absolutely, that's not a problem. I don't mind.
that's part of the
fixing that,
deal.
but
But why
Absolutely.
halfway and not, what was it? Initially, it was to pick off at Palmview?
Actually, no, Your Honor. The decree says that she's supposed to do the pickups and drop-offs from the residence of my client. She has been violating that for more than 2 years. She refuses to do the pickups and drop-offs. She signed that decree. It's been entered for a long time now. And that was the order that she agreed at the time. Now she doesn't want to do that
we have a
anymore.
decree?
And so my client was fine
here.
with
From Burke County.
my client was fine to amend that and give her what she wants. We understand she doesn't want to do the full pickup and drop off. And for whatever reason, and maybe at the time she just wanted to get divorced and she signed it. She changed her mind. Now we get that. So if she wants to give a little something, my client wants a little something. We'd be happy to meet her halfway, but the child support needs to be, stay the same. She wants both. She wants not only to change the pickup and drop off, so my client has to meet her, but she also wants to increase the child support. That we cannot do. My client's getting absolutely nothing. So, if she wants to increase the child support, fine. Keep the pickup and drop off the way it is in the decree at my client's residence. I've made her this offer. We've talked about this 1,000 times. You can't have everything your way. And not on a Rule 11 offer, not in agreement. So I thought my client gave up a little something. She gave up a little something. We meet each other halfway.
Well, then you all need to mediate now.
Okay, Your Honor.
You need to mediate, and if failure to mediate, it will be big problems, and then I'm gonna have to make some rulings. So there'll be some sanctions, if you all don't show up for mediation. You need to mediate. So is it still going to be Lucy Regalado?
Sure.
Lucy Regalado? Did you all get to meet or
Okay.
anything?
We need an order.
Yeah, we need an order, Ms. Smith, for
Okay, Your
mediation.
Honor.
But yeah, within the next,
I'll
what, 30
prepare
days?
that.
Within the
You
next
said
30 days?
do it within 30 days?
Yeah, within 30 days with Ms. Lucy Regalado. And you got to mediate?
And Your Honor, would this be splitting half and half, or would she pay since she reneged on the last one and no showed?
No, it'll be half and half.
Half and half, okay. I'll prepare that order, Your Honor.
Okay. And anyway, I think the child right now, I think Mr. Hurtado has him right now, right?
Yes,
For
Your Honor.
vacation. Okay. All right. Yeah, mediate it, then we'll come back.
And the enforcement, Your Honor, can we have that reset for the same day as the mediation, which is, I believe, September 8th?
That'll be afterwards, because I want to see what happens in mediation.
Yes, for a day
it'll be
after
abated.
the mediation.
It'll be abated, yeah.
That's in September, Your Honor.
Okay.
So
Yeah.
if we can just have her ordered to come back for that date as well.
No, I need new order setting hearings so that I can set those.
Those also?
Yes, sir.
Yeah, we need new orders for everything.
Okay.
And
I'll go ahead and prepare
Mr.
that.
Youngs, we need the order for the withdrawal.
Excellent. We'll submit that if it hasn't been already, but if it has, we'll just do it again, all right?
Okay, just make sure it's on. Yeah.
You need to grant them, America.
Yeah, it's granted. It was granted
Okay,
30, 40
and-
minutes ago. Yeah.
And
Okay.
how will I get a hold of Miss Juanita? Miss
Well,
Juanita?
we need phone numbers now. We need emails.
They
What's
have
your
them.
number? I'm sorry?
210?
San Antonio?
Yes, I
Okay.
used to live there. That's the
Okay.
thing. At the time of the decree, I lived in San Antonio, so I had no
Okay.
issue dropping off the child at his mom's, but now I live in McAllen.
Okay.
So
All right.
210, give me one sec. Miss Might should have it. She's called me before.
I've called and I have not been getting any response, Your Honor. So I prefer maybe email.
Okay,
so I can-
do you have an email, Miss Mendez?
We've emailed before too, 210-429-7976.
What was the phone number again? Was 210?
429?
429?
7976.
Is that the number you have, Miss Smith?
She's called
Yes,
me
Your
on
Honor.
that number.
Okay, what's your email?
J_Mendes25@yahoo.com.
All right, did you get it, Miss Smith?
I got it. Thank you. We'll send an email now.
All right, submit an order, please. New orders for everything, but especially for the one for the mediation.
On the new order setting hearings, if Ms. Smith can add her email, because she's getting notice.
Yes, I will.
Directly, unless she hires an attorney.
Okay. Well,
We
it'll be
will.
directly up until she has an attorney,
Yes,
if she gets an attorney. Okay, thank you all very much. Good luck out there, okay?
Thank you,
Judge.
Your Honor.
Have a
May I
great
be
day.
excused?
You all may be excused. Have a good day. Thank you.
Thank
you,
you.
Mr. Solis and Mr. Jerry.
All right, did Mr. Lee's make it back?
I'm almost done, Judge.
Oh, okay.
Almost.
All right, okay.
Oh, he's talking to the other court.
Okay, is this the last one or we get some more? Who else can we get? You want to bring those? Okay, Miss Aguilar, can you hear me? There she is. Miss Aguilar, you're here on F5264-19-4 in the matter of the marriage of Leslie Avendaño and Aaron Diaz.
Yes, Your Honor, good morning. Your Honor, I replaced Paloma Barrero on this case. So I filed my notice of appearance back in June, and we filed a motion for substitute service that you already signed. So we're now working on the service.
Okay, cool. There's no service on respondent, right?
Right.
Okay, that's what I understand. All right, so then we leave it alone.
Yes.
No action. Okay,
As soon as we serve him, Your Honor, we'll file our appropriate motion.
okay, that'll work. Thank you very much. You'll have a great day.
You too. Thank you, Judge.
You may be excused, huh? Bye-bye. All right, let's see. Do we finally have a?
I'm ready, Judge.
All right.
Maybe
I heard all about it, Judge. My friend Marion. Anyway, it was a good hearing.
I'm ready, Your Honor.
All right, let's see here. Court will continue with the July 19th, 2022 docket. CL 1944-69D. Richard Trevino versus Berta Graciela Salinas, American Excess Casualty Company. All right, Mr. Solis and Mr. What's your last name, Mr.
Zagoraris, Your Honor.
Zagoraris? Okay, Zagoraris. There you go. All right, Mr. Jerry Zagoraris. And we're here on a plea to the jurisdiction?
Yes, Your Honor.
All right, that's your motion?
Yes, Your Honor.
Yes, sir. You may go ahead.
Okay. I'm well aware that the court has read the motions, but I will just go through a couple things briefly. The court may remember this case in that a motion to enforce was previously signed by Your Honor in this court, but ultimately this results from an automobile motorcycle accident that occurred back in 2018. A settlement agreement was reached and signed, reviewed by plaintiff's counsel, and assumingly with the presence and awareness of the plaintiff. Drafting instructions were requested on behalf of the defendant, and the drafting instructions that were submitted by plaintiff's counsel did not comply with the request of defense counsel, nor did it comply with the settlement agreement that plaintiff's counsel signed and agreed to. At no point in time until well after the fact did we receive, or did the defendant receive, the appropriate documentation regarding the existence or non-existence of a hospital lien. But ultimately, plaintiff's counsel is complaining about a delay in the issuance of settlement funds and a breach of a contract that this court ultimately ordered enforced. So even after being ordered to, or being given 60 days to work out a lien agreement with the hospital, it still took close to 7 months for plaintiff's counsel to submit the properly requested drafting instructions. Therefore, that stretch was certainly well beyond the control of the defense and representatives of the defendant. By the plaintiff's own admissions, they read the settlement agreement, they reviewed the settlement agreement, did not provide the drafting instructions as requested by the defendant. And in their response, ultimately, plaintiff's counsel is simply stating that as a result of defendant's failure to promptly pay, this is on page 2, number 9, plaintiff asserted a breach of contract against the defendant. And this is all based on the fact that this is using the settlement agreement as a contract that plaintiff's counsel never complied with to begin with, and then making references back to the property code, which is irrelevant in this case, in that the controlling factor is the contract itself, the settlement agreement that was reviewed, signed, and agreed to. So based on that fact that the plaintiff had no standing against American Access Casualty Company at the time that the suit was filed, we would ask that the case be dismissed, as nothing has been shown that the plaintiff had standing at the time. And as the court is well aware, standing cannot be established after the fact, after the bringing of the suit. So with that, I will turn it back over to the court, Your Honor.
All right, Mr. Solis.
Yes, Your Honor. So at the August 20th, 2020 hearing on when Ms. Garza filed the defendant's motion to enforce, there was 2 arguments that I made. One, that it's not a valid release and we need to proceed with the negligence cause of action, i.e. the accident, or alternatively, it is a valid release, but we need to proceed with the breach of contract claim. Those are my two arguments. Okay. The court ruled that it was a valid release and only the tortfeasor was released, thus leaving the breach of contract claim. If you look at the order that was signed by the court on May 11th, 2021, the non-suit only dismissed the negligent driver Bertha Graciela Salinas. It did not dismiss ACC. What we have here is a fact issue. The fact issue is when was payment made, when was payment requested, and is there a breach of the contract for prompt payment? Obviously, we're alleging they are. Defense counsel is alleging there's not, but it's a fact issue. It's not a standing issue. Defense counsel is stating that Texas law does not allow a direct action against the insurance company. And I agree with him, but that is for a negligence cause of action. You cannot file a lawsuit against the insurance company when a negligent driver causes an accident. You can't file a lawsuit against that negligent driver's insurance company. The facts in this case are different. We're not suing ACC for negligence of the driver. We're suing ACC for failure to timely pay, which we are alleging is a breach of contract. Again, we now have a fact issue that the jury needs to decide, not an issue of law that the court needs to decide. So based on that, there is standing under a breach of contract because we are alleging ACC not timely pay once check drafting instructions were provided.
Okay. Yes, sir, Mr. Sagoratis.
Yes, Your Honor. The order for the partial non-suit that opposing counsel was referencing was signed and submitted by plaintiff counsel because when they filed a notice of partial non-suit, they filed a notice of partial non-suit only, as opposed to dismissing everyone. Again, we're going back to this breach of contract, which did not exist at the time that this suit was filed. There was no breach of that contract even then, because the timeliness of the payment is not material to the execution of the contract. So again, there is no breach. There was no breach at the time that the amended petition was filed, and as I've mentioned, the court cannot then establish jurisdiction after the fact.
After the fact, okay. Mr. Solis?
Your Honor, the fact that the pleading was amended doesn't make a difference as to when the breach occurred. After speaking with my client, we decided to proceed forward with the negligence cause of action for violation situations. Okay, but once the court decided that that was inappropriate, that did not mean we did not have a valid breach of contract claim. We mentioned the fact that there was failure to timely pay before suit was even filed, and we have emails to prove that. So the fact that ACC is stating they had no knowledge of this breach of contract claim, that they're unaware that it was a possibility is inaccurate and misleading. Again, we do have standing because there is a fact issue. This is not a matter of law, it's a matter of fact as to whether or not payment was delayed or not. And that's an issue that needs to be presented before the jury.
Okay, court will take this matter under advisement. Please submit your proposed orders, gentlemen, on
Your
clause
Honor,
numbers.
I have nothing else, may be excused. And lastly, thank you for accommodating me while I was arguing with the other court.
Okay, and thank you for waiting for your patience. It's been a long morning, guys. But no, court will take judicial notice of the entire file in CL 1944-69D. Once again, in the case of Trevino versus American Excess Casualty Company. And gentlemen, submit your proposed orders. And let me review this one more time, okay?
And Your Honor, I would just want to add that Mr. Solis made a representation that I said something about AACC not knowing or not being aware of a breach, and I made no such claims during that time. So I just want to make sure that whatever that was said there was not attributed to me, because it's not something that I said under any circumstances.
All right. All right, gentlemen, you're excused. Have a great day.
Thank you.
Thank you. Bye-bye. Under advisement. Okay, that's it right now? All right, thank you, staff.